Welcome to the first of Dehns webinar series. My name is Philip Webber. I'm a partner at Dehns and I've been working with patents for the last 28 years. Over that time, I've worked with many inventors, universities and companies, and I've got to know the sort of questions that are important for them as far as the patent system is concerned. So this first presentation is going to be an introduction to the basics of patents. I'm sure many of you will have questions during the course of my presentation, and so if you'd like to put questions through using the Q&A button at the bottom, then I'll try to deal with as many of those questions at the end of the presentation. So let's get started. So this gives you a summary of what I want to talk about today. I know there can be a lot of confusion between what is the difference between trademarks, patents and copyright, and so I want to deal with that right at the start and deal with any of those confusions. We'll then talk about patent claims, the most important part of the patent applications. Now, not all inventions are going to be good enough to get patents granted, so we'll then talk about what are the general criteria that the patent offices apply when deciding whether they're going to grant an invention or not. We'll then talk about what the patent office examiners do in terms of issuing search reports and examination reports, and we'll end up with a case study which should talk about enforcing your patents and giving an example of that. Now, one thing I'm not going to talk about today is how you get patents granted around the world in terms of the priority system and international systems. I'll talk about that in next week's seminar. So first of all, why do you want to patent your invention? If you take an example, Glaxo, they've made a new brilliant anti-cancer drug. It's going to cure all cancers that are possibly out there. They spent $4 billion on doing this, developing the drug, getting it through clinical trials, getting marketing authorization, and they put the drug on the market in a blaze of publicity. This is going to make billions for the company. What's stopping another company, let's call them Faxo, coming along the next day and saying, oh, we can get a sample of this drug, we can work out what's in it, we can reverse engineer it for a fraction of the cost that Glaxo have done. What's stopping them doing that? It's the patent system. If you get a patent for an invention, it gives you the right to stop others copying your invention for up to 20 years. So this gives you a chance to recoup the vast development costs that you put into your developing your invention, hopefully make a profit, and so you can develop further products for your company. And if you didn't have the patent system, who would invest billions of dollars in the terms of pharmaceuticals in the knowledge that somebody could just come along and copy your invention? Nobody would do that. And certainly in the drug market, if you didn't have patents, there wouldn't be any drugs. But the same applies to all other areas of technology, whether it's a new Dyson vacuum cleaner or a new gearbox for Honda. The same principle applies. If you get a patent for your invention, it gives you a chance to safeguard your market for a limited time in order to recoup your costs and to make profits for your company. So I want to illustrate my talk today with regard to a simple invention, and I'll be showing this later on in the course of my presentation. But it's a simple mechanical invention here. So some of my friends and I were sitting down by the river a couple of weeks ago. We were enjoying beers in the nice sunshine, and then tragedy strikes. The sun is out and our beer starts getting warm. Could be just the same with a sort of bottle of wine as well. Alternatively, if it was last week, we'd be sitting outside in the rain and our beer starts getting diluted, which is just as bad as a warm beer. So we came up with this simple invention here, an umbrella which can attach to a beer bottle, or it could be a wine bottle. So what sort of protection can we get for this? First of all, you'll have heard of copyright. What does copyright cover? Copyright mainly covers things like books, artistic works, photos, computer programs, music, but very much it only covers those specific things. And so if you have written a computer program, you will have copyright in that. Say your computer program digitizes images, but if somebody else wrote a program that did the same thing, but by using different program language, different algorithms, then you would have no right to stop them doing that, because you've only got copyright in your specific work, and the copyright does not extend to other people who independently might make that sort of work. In most countries, copyright comes into being automatically, although there is a registration system in the United States. As I said, infringement is only by copying that specific thing. So if people don't copy your work, they make something independently in a different way, you will not have the right to stop them doing that. You might have seen this little copyright symbol and the name of the author and the date that is put on bottom of books and things like that. Generally, that has no legal effect. It just warns people that if you copy that particular work, then somebody would have the right to take you to court. They could sue you for damages and get an injunction stopping you copying that. And copyright can be a very long right, certainly in the terms of songs and things like that. It can be up to 70 years after the death of the author. But it's a very specific work and it only covers the things that you've specifically done. So in the context of my invention here, I could take a photograph of my beer umbrella, I could make a drawing of it, and I would have copyright in that. And if somebody took that and put it in a book, I would have the right to stop them doing that. But it doesn't cover the general concept of putting an umbrella on a beer bottle. And that's really what I want to capture in this particular case. So what about trademarks? What do they cover? Well, if you imagine, say you've got a headache and you go to the local supermarket, you might see on the shelves there, you can either buy Nurofen or you can buy Tesco's own ibuprofen. You know that they've got exactly the same thing in them, but Nurofen, that costs £2, Tesco's own ibuprofen costs 20p. But you're prepared to pay for the more expensive packet because it's got a reputation of quality with that is associated with that brand. And that's what a trademark protects. You know where the Nurofen has come from, you've seen the TV adverts, and you're prepared to pay that extra because you know it's got quality associated with it, or a certain degree of distinctivity. So what can be registered as a trademark? Basically anything that can be written down, whether it's a combination of words, logos, designs, and colors. There's a trademark. One of the supermarkets has got a trademark for patting your back pocket because they are saving you particular money. There's another trademark on the smell of roses for tires, car tires. Don't know why, but it can be written down. Somebody's got one of the UK insurance companies that's got a trademark on a little musical thing. And so if anybody else uses that musical little extract in the course of their insurance services, then they would have the right to stop them doing that. You can register trademarks in up to 45 different classes. For example, if you take the word polo, that's registered for sweets, but it's also registered for Volkswagen. But when you buy a packet of Polo sweets, you don't think, oh, these are made by Volkswagen. So there's no confusion there. And so you can have them registered in different classes. You might have seen this little R registered, R in a circular logo. That means that the trademark has been registered. So it's been filed at the trademark office. It's been examined by the examiners, and you get much stronger rights than if it's just unregistered, which might be TM. TM means it's being used as a trademark, but it's not registered. And so you have much stronger rights if it's a registered trademark. And trademarks can go on indefinitely as long as you pay the renewal fees. And so there's some trademarks on beers that go back to 100 years now. And within Dehns, we have a whole trademark department which can register trademarks for you. But in the context of my invention here, I could put Beerbrella or Beerbrella, and I could put it on the top of my umbrella. And if anybody copies that, then I would have the right to stop them doing that if I register my trademark or use it as an unregistered trademark. But it doesn't cover the general concept of covering a bit of an umbrella attached to a beer bottle. And that's really what I want. And that's where the patent system comes in, because in patents, your rights are not defined by a drawing or a photo or any sort of brand logo. Your rights are defined in words. And so if I get a patent that covers any umbrella that attaches to a beer bottle, if I could get that, then anybody who makes anything that falls within the scope of that would infringe my patent, and I would have the right to stop them doing that. So that's just a brief distinction between copyright, trademarks. And so the rest of my presentation, I will talk exclusively about patents. So how do you get a patent? Well, you, the inventors, have to do the hard bit. You have to make the invention to start with. You would then approach somebody like me, a patent attorney, whose job it is to write the patent application and to file at the patent office. So I am acting on your behalf. The patent office examiners, and there are patent office examiners in every country around the world, it's their job to examine the patent application and to see whether the invention is good enough to be granted a patent. Hopefully it is good enough. And then once you get your patents granted, it is up to you to enforce them through the courts if you find anybody copying your inventions. So first of all, what's a patent attorney? What gives me the qualifications to represent you and get patents granted for you? First of all, at least in the UK, all patent attorneys are scientists. I mean, within Dehns, I think we've got now, I think it's 70 or 80 scientists in all different areas. We've got chemists, biotech people, engineers, mechanics, computer software people. So anybody who comes through our doors, we've got somebody who will understand your invention. And it is vitally important for you to for the patent attorney to understand your invention. For example, my background is pharmaceuticals and biotech. I would never deal with it with a mobile phone invention because I wouldn't understand it. And if the patent attorney can't understand your invention, you're not going to get a very good patent. Secondly, we have to take exams on the patent systems. First of all, on the UK patent system, and most importantly, the European patent system, because that's where most of our work is done. But we also have to have a good understanding of the patent laws around the world, because if we are getting patents granted for our clients in the United States, Japan, and all the other countries, we have to understand those patent laws as well. And a good patent attorney has to be a good communicator. Who are we talking to? Are we talking to the inventors in their scientific language? Are we talking to the CEOs of companies who want to know, well, when's my patent going to get granted and how much is it going to cost? Or are we talking to the patent office examiners in their legal language and arguing with them in order to get the patents granted? So we wear a number of different hats, and so we have to remember who we're talking to at any particular time. But basically, my job as a patent attorney is to guide you through the patent process and to get you the best patents, the broadest patents that I can possibly do. So what is a patent application? It's not just simple form that you fill in, name, address, title of the invention, send it off to the patent office. No. A patent application is basically a book on your invention. It might be 10, 20, 30, 50, 100 pages that describe all details of your invention, how to make it, and a particular definition of it. And all patent applications are published about 18 months after they've been filed. And so these are all in the public domain. And so you can readily see what your competitors are doing, and equally your competitors can see what you are doing as well. And if you pick up any patent application, they've all got the same basic subdivisions. On the outside of the patent application, you've got details of who the inventors are. The inventors have a right to be named in patent applications. The patent application is quite often filed in the name of a company. There will be the date that the patent application has been filed, and then quite often an abstract or a description of the invention. So anybody looking just at the front page of the patent application can get the basic details. Inside the patent application, a good patent application should read like a good story. Yeah, what is the invention? Start off with a brief passage about talking what the invention's about. And then a bit on the background to the invention, because you want to educate the patent office examiner about what's been gone before. And so the patent office examiner will then understand how your invention is different from what's been done before, and hopefully understand the merits of your invention and how brilliant it is. There will be some statements that specifically describe your invention, examples, the different features of your invention, preferred features. There will be some examples. There's an example section to show how to make the invention and show that how it works. At the end of the patent application, or sometimes at the very beginning, there might be some drawings which illustrate some examples of your invention, or some graphs showing some data to show that it works. But the most important part of the patent application are the claims section. The claims are specific short paragraphs, sentences, which describe your invention in words. And so when it's my job as a patent attorney, so when my client comes to me and sort of says, right, I've invented this, and sticks it down on my desk, I have to convert that into words in the patent application. I'm not allowed to use any diagrams or drawings. The invention has to be defined in words. And that's the most difficult part of the patent job. yeah, converting inventions into words, and the most important part. So my invention here, as I said, there's actually a US patent that covers this. So I've made this in my workshop here in Oxford here. There is no patent that covers this in the UK, and so I can quite easily, I can do that legally without copying the invention. So this is the US, what the US patent, this is how the invention was defined in the United States. So first of all, what have we called it, this attachment? We've just called it an apparatus. An apparatus for use with a beverage container. So we haven't said it's a beer bottle or a wine bottle. Beverage is a very old English word that just basically means any drink. So we've said it's an apparatus for use with any drink. Yeah, we didn't want to limit it to beer bottles or wine bottles, so we've kept it broad. And it has to be for use with. And in patent language, that means it has to be suitable for use with a beverage container. And this apparatus is said to be comprising. In patent law, comprising means that it's got the following features, but it could have other things as well. So in this particular case, we've broken down our invention into 3 different features. First of all, the bit that attaches to the bottle. We've called it a means for removably attaching. A means just means anything that removably attaches the apparatus to the beverage container. So we haven't said it has to be an aluminium clip, because what happens if somebody comes along with a Velcro strip or an elastic strip or something like that? That would do the same sort of thing. But if we limited it to an aluminium clip, then somebody could easily get around the scope of our invention. So that illustrates a general principle of patent claims. You want to define each of your features as broadly as possible in order to cover variants and modifications that your competitors might want to make. Because if you don't cover those, then you're leaving your claims open for somebody to easily get around them. The second feature is a shaft. And in this case, we must specify that it's attached to the clippy bit. And in this case, the umbrella needs to be above the beverage container. So therefore, we've said that it's extending vertically with respect to the beverage container. So here we've not only defined it as a shaft, but we've also defined the relationship that that feature has with the other features, because it's important in this particular case. And we said it's extended vertically because, yeah, if it extended horizontally, then it wouldn't work. It wouldn't shade the beer bottle, would it? And the third feature, an umbrella. I mean, we could have called this a shading thing, but everybody knows what an umbrella is, common term in the art, and so we've used that. And equally, we've said it has to be coupled to the shaft above the attaching thing so as to shade the beverage container. So here we've said what the feature is, an umbrella, we've said what it does, and we've said what its function is. So here we have a simple mechanical invention which defines each of the 3 essential features of the invention. We haven't said that the shaft must be aluminium, because what happens if somebody replaces that with a steel one or a plastic one? So we've kept each of the features as broad as we can. So that is our invention. We've claimed it. Are we going to get a patent for it? What are the criteria that the patent office examiners are going to look at when they're judging whether to grant a patent for our invention or not? First of all, the invention, and whenever I refer to the invention, I mean to what is being defined in the claims, not the inventor's idea of the invention. It's what the patent attorney has written as the claims in the patent application. So what you put in the claims must be novel, must be new. It must also be inventive in terms of not obvious in light of what's been done before. And I'll discuss each of the novelty and inventive step more in just a second. The rest of the patent application, that's all your description or your diagrams and examples, must show at least one way of putting the invention into practice, because if you can't make your invention, then you shouldn't be entitled to get a patent, stop other people doing that. And if you're claiming broadly, then you need some examples to show that it's justified, that people are, that your claims should be broad. So this is probably the most important slide in my slide deck. So if you've been asleep up till now, just sort of wake up for at least this slide. So this is what the European Patent Convention, that is the EPC, says about whether your invention is new or not. And all patent laws around the world have something virtually the same, slightly different language, but the same principles. So first of all, the invention shall be considered to be new if it doesn't form part of the state of the art. Okay, what's the state of the art? The state of the art is everything that is in the public domain before the date that you filed your patent application. So a lot of people think that the state of the art, yeah, patent attorneys call this the prior art. A lot of people think that it's just written publications and things like that. It's not. If you've been to a conference and you've given out details of your invention to the conference audience, you have put information of your invention into the public domain. If you've been down to the pub last week and you've been discussing your invention with a big group of people there and it's not confidential in any way, then you have put your information into the public domain. So for this reason, it is vitally important to keep all details of your invention confidential, at least until the date that you file your patent application. So quite often patent office examiners, when they're examining patent applications, will do a Google search on the inventors. Right, well, let's have a quick Google search. Let's put in the inventor name. Let's see what he's been doing. Ah, good for the inventor. He's been at a nice conference in Hawaii a couple of weeks ago. Oh, I can follow, yeah, here's a copy of his abstract. Oh, I can even download a complete copy of his presentation. No patent for this chap. He's given away all details of his invention. So whether you're an inventor or whether you are in management, it is vitally important that your inventors, your colleagues, anybody who has details of invention keeps details of the invention confidential, at least until your dates that your patent application has been filed. Just to illustrate this concept of novelty, here's a picture of me when I was a bit younger. So the old cutthroat razor, people used to bleed to death when they were shaving. Then Gillette came along in the, I think in the 1910s, that sort of, yeah, 100 years ago now. And Gillette came up with this concept of a disposable safety razor, narrow blades behind guards. And so looking at the features of the safety razor compared to the cutthroat razor, totally different features. And so the safety razor is novel over the cutthroat razor. So novelty is a black and white issue. You have to compare what you are claiming in your patent application against everything that's in the public domain. So then I think it was about the sort of 70s or 60s or 70s, 2-blade razors came along. Then we've had 3-blade, 4-blade, 5 blades. I saw one with 7 blades the other day, and I think I've seen one with 5 blades with a nose hair trimmer. So each of these, if there were patent claims to each of these other razors, they would be novel over what's been done before, because 2 blades is novel over 1 blade. 3 blades is novel over 2 blades. 7 blades with a nose hair trimmer is novel over 7 blades. And so novelty is a black and white issue. Okay, so that's the first criteria that your invention has to satisfy. The second criteria is inventive step, and you must look at inventive step totally independently from novelty. So what does the European Patent Convention say about inventive step? An invention shall be considered as inventive if, having regard to the state of the art, so bearing in mind everything that's in the public domain before the date that you filed your patent application, are your claims, are what you claim, obvious to a person skilled in that area of technology. So whereas novelty was a black and white issue, are all details of your invention known in the public domain or not? Obviousness is very much a gray issue. And I spend a lot of my time arguing with patent office examiners where they say, well, no, there's this document that says this and this document says this. And when you put the two of them together, well, it points straight to your invention. Your invention's obvious, isn't it? And I say, well, no, it's not for these particular reasons. So when looking at obviousness, you need first of all to think, who is the person skilled in the art? And so in going back to my original example of a cancer drug, who is the person skilled in the art there? Perhaps a postdoc or somebody working in a lab who is familiar with all areas of cancer technology. So putting yourself in the shoes of that person and knowing everything that's in the public domain, is it obvious to go from what has been done before to what you're claiming in your patent application? Certainly the European Patent Office and increasingly the US Patent Office these days tests was it obvious to try your invention with a reasonable expectation of success? That's one of the tests that they apply, but there are a number of other ones. But I say obviousness, you can argue for quite a long time, and so yeah, and we do argue a lot with examiners about this sort of issue. So going back to my example here, the old jumping from the cutthroat razor to the safety razor. Yeah, the safety razor's got very different features. Arguably, you've got a good invention there, and it's not obvious. But once one blade is known, is it obvious to make 2 blades, or 3 blades, 4 blades, 5 blades? In any particular case, if you're arguing inventive step, you need to look, yeah, what are the technical arguments that you can put forward, and particularly any evidence that you can put forward to show why it would not be obvious. Just simple arguments saying, no, it wouldn't be obvious, don't run with the patent office. You need solid technical arguments and evidence in some cases. So looking at this, I mean, the 1 blade razor is known. Is it obvious to make 2 blades? Well, one argument I've heard is that the first blade in the 2 blade razor, the first blade comes along and lifts up the hair on your face. It pulls it up a little bit, so that then actually when the second blade comes along, it actually cuts the hair finer. And so if that was not obvious, if it was a surprising effect, then possibly you could get a patent on a 2 blade razor, even if 1 blade razor is known. But 3 blades, 4 blades, 5 blades, I think you'd be struggling. So those are the 2 main criteria that apply to the claims. The rest of the patent application, yeah, you must, this is one of the other provisions that applies to this. This is quite often called enablement. You have to show how to put the invention into practice. And so, for example, if you're claiming a rocket that travels 5 times faster than the speed of light, you're going to struggle to show how that works. And so if you can't do that, you're not going to get a patent for it. So you have to show how the invention can be actually be made. Also, that the claims that you use must be clear. And so you can't use words like high temperature or low temperature, because yeah, what do high and low mean? You have to be very clear. So at high temperature, you would have to say at a temperature between 50 and 100 degrees or something like that. So it's important to use very clear words. And also the examples that you put in the description must justify the scope of what you're claiming. So if you've got some experiments to show that your drug works in mice, is it reasonable to extrapolate that to humans or any animals? If you're claiming any animals, yeah, does it work in elephants? So those are the basic criteria that we've now looked at. So we've got our patent application filed. We've looked at some of the criteria that the patent office examiners will think about. What does the patent office examiner do when he gets the invention, when your patent application lands on his desk? The diagram on the left here just shows the basic timeline. So the patent attorney will generally file your patent application for you. The examiner, at the beginning of the examination process, well, he needs to know what is in the prior art in order to compare what you are claiming in your invention against what is in the prior art. So the first thing he will do is do a search. So, and he will search anything that he can get hold of. As I said earlier, it's not just printed publications, and it's not just scientific publications. So yeah, he might Google the inventors, see what they've been up to. The patent office examiners will have good access to patent databases, and so they will look at those, but they will look at those purely as documents that are in the public domain. Forget the fact that they're patent applications, they are just technical publications that can be really easily searched. The examiners will also search scientific databases, literature, trade journals, I say anything else that they can get their hands on, and then they will produce a search report. A search report is just basically a list of the documents that the examiner thinks might be relevant to judging whether your invention is novel and inventive. And they will send this search report to the patent attorney in the first instance. So in this particular case, the patent office examiners found 3 US patents, but I say they could have been any particular documents. The fact that they're patents is irrelevant. The examiner will assign a category to each of the documents. X means it's very bad. Y means it's not quite so bad, basically. And in your patent application, you will probably have more than one claim, and so the examiner will give you an indication of which claims are relevant for that particular document. And the examiner will often send us copies of these documents or show where they can readily be available on the internet as well. So having received this search report, I can then go through the documents with the inventors, and we can make a decision as to, yeah, is the search report really bad? Is there any chance of proceeding or not? If the examiner's found some documents that pretty much disclose all features of their invention, then you can just give up now. Don't waste your time, don't waste your money on any further, but hopefully you can hopefully get something more granted. So this slide here at the bottom here shows 3 examples of pictures from the search report that the examiner found with my Beerbrella. So, but before we look at those, just remind ourselves briefly about what we claimed in the patent application. So this is our patent claim. So for this claim to lack novelty or inventive step, then each of these 3 features must be disclosed in the public domain already. So it must show something that removably attaches to the apparatus. There must be a vertical shaft, and there must be an umbrella. So looking at the first one here, it's clearly got an umbrella, it's got a bit of a vertical shaft, but it's also got a diagonal shaft as well. And this looks like a can of Coke or whatever, but this doesn't, I don't think this removably attaches to the bottle or whatever. I think in this case, and I think probably in this case also, in the second case also, the bottle or whatever doesn't attach to it. I mean, what does removably attach mean? For example, you could define attaches, if you turn it upside down, then it doesn't fall out. And I think in this case, both the 1 and 2 here would fail that, because I don't think it attaches. And so I think we're novel over these first ones. And this third one is actually WD-40. It's a sort of aerosol lubricant. Why has the examiner cited this? I think the reason he put it, because it shows a shaft, in this particular case a straw, removably attaching, that is clipping to some sort of bottle. So the examiner is saying that, okay, since although all of the features of our claim might not be disclosed in any one example, individually they are known. So I think from these we can say that we're probably novel, but we might have problems with inventive step. So hopefully, if we manage to survive the disclosures of the search report, we can pay some more money to the Patent Office examiner, and he will then produce a full written examination report. And these things, yeah, so in these written examination reports, the examiner will then look at all the standard criteria for patentability. So he will look at the novelty of the invention, the inventive step, whether you've got full details of how to make the invention, the clarity of the language, and any of the other criteria for patentability. And so he will produce this written report and then send it to the patent attorney. Now, the first thing, most important thing with regard to these reports is that there will always be a deadline for filing a response. Now, in Europe, you normally get 4 months. That's extendable up to 6 months. In the United States, you generally get 3 months. That's extendable up to 6 months. But it is vitally important that we deal with these examination reports within those deadlines. As I say, some of them can be extended, some of them cannot. And so whenever the patent attorney will report these examination reports to you, do make a note of the deadlines, because all the issues have to be dealt with within that sort of time frame. And when you get these examination reports, you don't know whether, and I don't know as a patent attorney, whether the examiner is going to come back and say, yeah, this is the best invention I've seen this year, I'm going to send this to grant straight away, or you're going to get a really long examination report. I had a case last year from an American examiner where the examination report was 50 pages long. The examiner objected to everything from, you have missed a comma on page 2, line 7, to you have used the word the instead of a on page 3, line 4, to issues of novelty, inventive step, and all sorts of other things as well. And so that's one of the, well, I won't call it a problem, but it's one of the issues with the patent system, is you don't know whether your patent is going to sort of sail through to grant, or you're going to have a real challenge with the examiners who raised lots of objections. And remember that in each country that you file patent applications, the examiners will look at your invention essentially independently. And so the American examiner might say, no, really don't like this invention. I'm going to give you a really hard time. The European examiner might say, yeah, this is the best invention I've seen this year. Here's your patent. But it's the patent attorney's job, my job, to look through these objections and decide, yeah, are they reasonable ones or not? So within the time limit for filing a reply, I need to receive the report it to you. You need to think about it, possibly discuss with your other inventors, then give me instructions on how to deal with the response, and then for me to file the response with the patent office. So all that has to be done within the time limit that is allowed for replying to the report. So in this particular case, the examiner said the term beverage in claim 1 is ambiguous and lacks clarity. Now, okay, the word beverage is a very old English word, but in reply to that, I would take a copy of the English dictionary and said, look, the word beverage is clearly defined as any drink. It's a well-known word. I would file that with the examiner, and I would expect the examiner to withdraw that objection. In this particular case, the examiner has accepted that the claims are novel in the light of the documents, but he's raised questions of inventive step. And so, yeah, I would be looking for you, the inventors, for help with having to deal with dealing those objections. Yeah, what technical arguments? Why would it not be obvious to take a clip from WD-40 and apply that to the other things that are already known? So, but hopefully, oh, sorry, before I go on and sort of talk about grant, I just want to sort of hammer home this issue about your patent claims on the prior art. So the diagrams here, yeah, shown in red is everything that's in the public domain. That's the prior art. Your patent claims are shown in blue here. So as long as the blue circle doesn't overlap with the red circle, you are novel. You are different from what's in the public domain. The extent of the gap between the blue circle and the red circle is your inventive step. So if you are very close, then the patent office examiners are likely to say, well, your invention's obvious because you are quite close to what's being done before. Or if you are a lot further away, say if you've made a stunning new invention, opened up a whole new technical field, you're a long way from what the prior art is, then you've got a good invention, you've got a good inventive step. So as an example of that, say you are the first person to invent a car. So, excuse me for a second. Right, so yeah, say you're the first person to invent a car. So your patent attorney says, right, well, let's claim all cars. But what you've really made is an electric car, and you particularly found the electric cars with 6 wheels work brilliantly for some reason. So, but you, as far as you're aware, nobody's ever made a car before. And so we've claim 1 of our patent application is to all cars, but we've also got a claim 2 that is restricted to electric cars and a claim 3 to electric cars with 6 wheels. We file the patent application at the patent office, the examiner does his search, and he finds out, well, actually, diesel cars have been invented in China a long time ago, but we didn't know about that. So looking at each of our claims of novelty and inventive step, our claim 1 clearly lacks novelty because diesel cars falls within the scope of all cars. Therefore, we can't have claim 1. We are going to have to delete claim 1. So we then fall back to claim 2. Now, electric cars do not overlap with diesel cars. Therefore, we are novel. But because they both refer to cars, electric cars, yeah, is it obvious to make an electric car given that diesel car was known? The examiner might say, well, diesel cars are known, batteries are known, therefore it's obvious to make an electric car that's got batteries in it. If the examiner were to make that sort of argument, then he might assert that our claim to electric cars lacks inventive step. And so we would have to argue against that. And so we would have to make a decision, yeah, do we try to keep our claims to electric cars and argue that those are not obvious over diesel cars? Or do we come down to claim 3, where we've got some really good data, and electric cars with 6 wheels, yeah, there's a much bigger inventive step gap over that compared to diesel cars. So do we try to get broad claims to electric cars and argue with the examiner, or do we come down to claim 3 and limit it to electric cars with 6 wheels, but accept that that is a much narrower scope of claim? So these are the sort of issues that we quite often raised whenever we deal with examination reports. Yeah, do we argue with the examiner, or do we give in because we want the patent granted quickly, or do we really need to argue for a broader claim because we want to keep our competitors off that particular patch? So we file a response to the search report. It goes back to the examiner's desk. The examiner will reassess the patentability of the invention in the light of the arguments that we've made and any amendments that we've made to the claims. Quite often we do end up amending the claims to sort of bring it a narrower scope, and that quite often appeases the examiners, but not always. But hopefully at the end of the day, we get the patent granted. So you've got a patent granted, it gives you the right to make your invention and to sell it. No, it doesn't. A patent is a negative right. It gives you the right to stop others making, using or selling your invention or importing into the country where you have granted patents. So as I said, if you wanted to stop people making your invention in the United States, you need a US patent, and I'll talk about how to get those in other countries next week. Your maximum term of patents these days is 20 years, but it's up to you to enforce your patents in the courts if you get your patents granted. So finally, let's talk about, just give an example of a competitor's products. Now, if I can just see if we can bring it back to me. All right, here we go. Hopefully you can still see me here. Right, so here's my, let's move back a little bit. So here's my Beerbrella, and I've got a patent for this. Okay, so I've been selling that. It's been doing really well. I've been making millions of pounds for this. The competitors noted that. And so a competitor's product, I've just realized, has come onto the market. And so this is what he's selling. So again, we have some sort of clippy thing, and we have an umbrella. Now, my question is, can I use my patent to stop him making this? So first of all, the fact that I'm making this is irrelevant. So let's get rid of that. What I have and what I would want to use it to stop him doing this is my patent. So remembering that my patent requires that this product has to have 3 features, if you remember. It has to have something that removably attaches to the beer bottle. It has to have a vertical shaft, and it has to have an umbrella. Now, the question for you is, does this product fall within the scope of my patent? So just to remind you, it has to have a removable attachment, it has to have a vertical shaft and an umbrella. So what do you think? Does this fall within the scope of my patent? Can I use my patent to stop this competitor's product? Well, I'll give you the answer. Okay, well, part of the answer. So first of all, it was called an apparatus for use with a beverage container, and I think this clearly is an apparatus for use with a beverage container, a wine bottle. It has something that removably attaches to the wine bottle. I think, yeah, it hasn't got a metal clasp like the one I made, but this stretchy elastic falls within the scope of my claim. There is a shaft that attaches to this and extends vertically, or does it? I mean, that is the shaft. Does that shaft extend vertically? I mean, there's a bit up here that does, but that's clearly not vertical. And what about this? Is that an umbrella? What's an umbrella? What's the purpose of an umbrella? The purpose of an umbrella is to shade the beer bottle. And this clearly does, even though it's not a standard umbrella. So we go to court. So I've got the patent. I would say to the judge, this chap has copied my invention. I'm losing £1 million a day because of this. I want to claim £1 million in damages, and I want an injunction to stop this chap copying my invention. And the judge will say, right, can you show that this falls within the scope of your claims? And I will say, right, well, that's clearly a removably attaching thing. this has a bit of a vertical shaft here, even if this isn't vertical. And this is clearly has the function of the umbrella. It is an umbrella because, yeah, it has a metal rim, it has a fabric bit in like all umbrellas, and it has the same function of protecting my umbrella, my beer bottle. So it is an umbrella. The other side who's making this is going to say, this doesn't fall within the scope of your claims. Your claim specifically says that this shaft must be vertical, and that is not vertical by any means. And this is not an umbrella. An umbrella is something that goes up and down and pops up, and this is not, okay, this does go up and down, it pops up, but it's not an umbrella. And the judge has to make a decision as to whether that falls within the scope of the claims or not. And if you don't like the decision of the judge, then you can appeal it up to the next level, up to the Court of Appeal, where you've got 3 patent judges in the UK. If you don't like their decision, then it goes up to the Supreme Court, where you've got a lot more patent judges. And so it's only when you get a final decision from the highest court in the land, if you do appeal it that far, that you can decide whether that falls within the scope of the claims of your patent. And even then, that's not the end of the story, because even if the highest court says, yes, that falls within the scope of your patent, the chap who makes this is not going to say, okay, here's your £10 million. He has a trump card. He will try to argue that your patent should never have been granted in the first place. So in any of these court proceedings, there's generally sort of 2 parts. First of all, the infringement part, whether your product falls within the scope of the claim. There will secondly be a validity part. So even if the product does fall within the scope of the claims, the competitor will attack the validity of your patent. That is, whether it should have been granted in the first place. And so the competitor probably knows a lot more about the background to your invention. The competitor might have been at your conferences in Hawaii years earlier where your inventors disclosed details of your invention. So the competitor will attack whether your claims are novel, whether they're inventive, whether you have sufficient details. And if the competitor can show that your patent should never have been granted in the first place, then your patent's dead and you will come away with nothing. So in any court proceedings, it's always going to be a double-edged sword. You might come away with £10 million in damages and an injunction against the competitor, but you might come away with a dead patent if your competitor can show your patent should never have been granted, or they might sort of limit the scope of the patent. But in court proceedings are in fact incredibly rare. And so the vast majority of patents are never challenged in the courts. And in fact, oftentimes the mere idea that, or the mere knowledge that your competitors have got patents is enough to keep them off your particular field. And so, yeah, it's not worth worrying too much about sort of litigation at the end of the day, because yeah, the vast majority of patents are never actually litigated. So that in fact ends my presentation. I hope it's been really useful for you. I'm hoping that my colleagues will send me some of the questions that some people have raised during the course of the talk. Yes, I can see them sort of coming through now. So I'll try to deal with a couple of these, and then I'll pass you back to my colleagues just for some final words. So a question from Chris Lindsay: do patent attorneys generally help which stages after the patent is granted? For example, if a competitor infringes your patent, or do you have to engage a solicitor? Yeah, so the question here is, yeah, so do patent attorneys just deal with the pre-grant stages or the stages after the grant as well? It matters from country to country. In the UK, most UK patent attorneys will primarily deal with up to the grant stage. However, if they've got European patents, there are some stages within the European Patent Office. There are opposition and appeal proceedings over there where European patent attorneys regularly deal with those, and they are the best people to deal with European oppositions because they are the best, they are most familiar with those sort of proceedings. So if your patent's been challenged at the European Patent Office, then patent attorneys will deal with that as well. As far as UK is concerned, there are increasingly a number of patent attorneys who have got what's called a litigator qualification, which enables them to deal with the UK courts, certainly the lower parts of the UK courts. And those are becoming more and more common these days, particularly in the sort of mechanic or more in the mechanical type invention field. But solicitors obviously are more adept and more familiar with dealing with the UK court proceedings, and so quite often you will in fact instruct a barrister or a solicitor to deal with the UK court proceedings, but the patent attorney will be there in the background, because quite often the patent attorney will have written the patent application. They will be most familiar with the invention and the patent, and so they will help in the background at least. So I hope that answers your question. Another question from anonymous attendee. What if there is a competitor who also wants to produce a product similar to the patented one? Would it have to pay the patent holder to do so, or is that simply not allowed? Well, the question here is, what do your patent claims cover? If the patent claims, in my, going back to my example, if I just claimed a metal clasp around here, and that's all of that I had in my patent application, then I wouldn't have been able to stop the person producing this, because this is not a metal clasp. So in all cases, you need to look explicitly at what the claims cover, because the claims will define exactly what your competitors are allowed to do and what they're not allowed to do. So yeah, it's the scope of the claims that really defines that. So, and that's the reason that whenever a patent attorney is initially looking at your invention, one of the first questions that the patent attorney should ask is that, okay, you've made this, how else could you do this? What sort of modifications or variations of this could a competitor do? So you need to put yourself in the shoes of the competitor and think about, right, if I wanted to get around that, what would I do? And so that's why you need to think about all the variations and modifications of the invention, and for each of the features of the invention, in order to make sure you capture all of those in the patent application to keep your competitors off the whole of that patch. Another question from anonymous attendee: is the patent officer also a scientist and expert on the topic he is examining? Generally, yes. The patent office examiners will have similar qualifications to patent attorneys. They will have scientific backgrounds, and they will be experts in the patent law. The bigger the patent offices are, the more experts that they will have. And so the European Patent Office is obviously bigger than the UK Patent Office. And so, yeah, they will have experts in all the different areas of technology. And so whatever area of technology your invention is, your patent attorney, your patent application will land on the desk of an expert in that particular area. And so yes, you could, and generally patent examiners are pretty good at understanding these things. You do get occasional ones who just don't understand it, but that's where the patent attorney can come in and help educate the patent examiners. Who are examiners? Do they have day jobs? Well, yeah, their day job is as a patent office examiner. In the UK, they're down in Newport in Wales, or actually they're probably at home at the moment, I suppose, because of the COVID thing. But yes, it's their day job to search and examine patent applications all day. I know the European examiners generally take between sort of 2 or 3 days to do a search and examination report on each invention. And so, yeah, that is their day job. If a patent is granted, would you therefore invest further money and resources in particular date, and then years later somebody convinces the court that your patent should never have been granted? Would there be a ramification or liability on the patent office? So right, so the question here is, can you sue the patent office if they granted a patent when it shouldn't have been granted? The answer is no. The patent office has no liability. And certainly in the United States, if you are applying for a patent in the United States, you have an obligation to tell the patent office examiner about everything that's in the public domain. So you have to tell them, if you've previously done a search, you have to send them copies of all the documents. And this is a really strong onus on you regarding United States patents to tell the patent office examiner about everything you know in the background. And so the examiners then have to can take that into account and judging whether your patent should have been granted or not. Most countries don't have that onus. If you know about prior art documents that might affect whether your invention is novel or inventive, then technically you don't have to disclose those to the patent office. If you know that but I would say that if you know that a document knocks out the novelty of any of your claims, then I would amend your claims. It's not good to try to get patents granted in the knowledge that you should not have get them granted. If there are documents that might affect the inventive step of your invention, well, inventive step is always arguable, and so there it's a more difficult decision. But as far as the patent office is concerned, then yeah, you have no liability if they get it wrong. And finally, when considering patent infringement, is it when a competitor goes to sell the product or when they produce them? Well, if you look back at my slide for the rights that you get on a patent, a granted patent will give you a right to stop somebody selling your invention, manufacturing it, offering it for sale, or importing it into the country where you've got granted patents. So those are the main rights that a granted patent will give you. And so if a competitor is selling your product, then you have the right to stop them doing that, or they've got a manufacturing plant and you think they're manufacturing it, you can go in and try to shut down that plant. Okay, I think those are the last of the questions. And so I'm going to finally invite my colleague Michelle to say some final words about the other webinars that we've got coming up. And certainly just before she does that, just a quick plug for myself. Yeah, I've talked about the getting patents granted, examination reports, things like that for one country. Next week, I'm going to be talking about how you can extend that to getting patents granted around the world. So I think that's one of the things Michelle will be talking about. So Michelle, can you take over from here?
Sure.
Thank you.
Hi everyone, I'm Michelle. I'm the Business Development Manager at Dehns. Thanks for attending our IP Basics webinar, and thanks Phil for presenting and guiding us through the process. I actually think we have addressed all the questions, but if you do come up with any more questions you'd like answered, please just send us an email, and we can include any relevant information in our follow-up emails to this webinar. We do have a whole series of webinars planned for summer. Phil's continuing the Foundations of IP theme next week with a webinar on getting patents filed in other parts of the world. Please do sign up for this if you haven't already. We have webinars on supplementary protection certificates and the ins and outs of patenting software in our June and July schedule, and there are more to be confirmed for July and August. All our webinars are listed in UK time zones, so that'll be 12:30 UK time, and currently we have them all planned for Thursdays. I'll send out the registration links for upcoming webinars in our follow-up email, but get in touch if you need any more info and if there are any topics you'd like us to include in our schedule, because we're very happy to receive your suggestions. We've also, very excitingly, ventured into the world of podcasts, and this week we've launched the IP podcast. These are 15-minute bite-sized episodes on the IP process and topical IP issues. I'll also include this link to our first episode in our email, but you can find all the podcast episodes on our website in the Inspired Thinking section and on all the usual podcast platforms, iTunes, Spotify, etc. So yeah, I think we'll stop here for today, but thanks again, and I hope we can see you all or welcome you all to another one of our webinars very soon. Take care, everyone.
Thank you. Bye-bye.